Welcome to the Synchrony Law Vlog. I'm Suzette Squires, and in this vlog I'm going to look at a recent decision of the Supreme Court which will come as welcome news for employers seeking to enforce restrictive covenants. This is the case of Egan Zehnder Limited and Tillman, the first case on employment restrictive covenants considered by the Supreme Court in over a century. By way of recap, under UK law, post-termination restrictions in employment contracts are considered to be a restraint of trade and therefore void unless they go no further than necessary to protect the employer's legitimate business interests, such as its confidential information, client relationships, or the stability of the employer's workforce. In practice, this means that employers need to balance the extent of protection afforded by a covenant against the risk that it will be considered unenforceable. The Egan Zehnder case concerned action by an employer to enforce a restrictive covenant against a senior employee who joined a competitor post-termination. The employer argued that she had breached a non-compete restriction, but the employee argued that the wording "or interested in" within the restriction prevented her from holding a minor shareholding in a competing company and that the clause was therefore unreasonable. The Court of Appeal agreed and importantly refused to sever the wording, meaning that the non-compete restriction was void. In an important decision for employers, the Supreme Court overturned this finding. Whilst it held that "interested in" did cover minor shareholdings and was therefore too wide to be enforceable, it disagreed with the Court of Appeal and found that this wording could be blue-penciled. In other words, as the clause could be read without these words in a way which made sense, and because the change didn't generate a major change in the overall effect of the restriction, these words could be deleted. Egan Zehnder could therefore rely on the remaining non-compete restriction. This is a good decision for employers, suggesting that courts would take a pragmatic approach to drafting issues which could render an otherwise reasonable restrictive covenant unenforceable. It remains vital for employers to ensure that restrictions are drafted to be as reasonable as possible, and the courts could refuse to narrow their scope if litigated, on the basis that doing so would constitute a major change in the overall effect of the restriction. Employers looking to rely on this blue pencil test could also be penalised in terms of paying the employee's litigation costs. If you'd like specific advice on drafting or enforcing restrictive covenants, then please do not hesitate to contact us.